Today, we're going to address several significant lawsuits in Illinois that have created exposure for employers and others collecting data under the Illinois Biometric Information Privacy Act that was enacted in 2008. In a case from several years ago, Rosenbach versus Six Flags Entertainment Corporation, the mother of a teenager sued Six Flags Entertainment Corporation under the Illinois Biometric Information Privacy Act. The plaintiff alleged that the theme park scanned her son's fingerprint without obtaining written consent and without properly disclosing the company's business practices relating to the collection, use, and retention of the fingerprint data. The Illinois Supreme Court in 2019 unanimously held that a plaintiff does not need to plead actual harm or injury resulting from an alleged BIPA violation in order to seek injunctive relief and liquidated statutory damages of up to $5,000 for alleged violation. In 2023, the Illinois Supreme Court added on to that decision with two substantial decisions that expanded the exposure that employers face, as well as other collectors of biometric information. The first case is Cathrone versus White Castle, which answered the following certified question from the Seventh Circuit Court of Appeals concerning BIPA. Do sections 15B and 15D claims accrue each time a private entity scans a person's biometric information and each time a private entity transmits such a scan to a third party respectively, or only upon the first scan and first transmission? In February of 2023, the Supreme Court issued its decision. In a 4-3 decision, the court held that a separate claim accrues under the Act each time a private entity scans or transmits an individual's biometric identifier or information in violation of Section 15B or 15D. And so in that case, there were a substantial number of employees for White Castle. If they were to pay each of those fines at $1,000 per, the total number would have been $17 billion in damages. The second case that the Illinois Supreme Court heard and decided was Timms versus Black Horse Carriers. It was heard in September of 2022, and the court in that case decided that the applicable statute of limitation for violations of BIPA was 5 years and not the 1-year defamation statute of limitations that otherwise might have governed. These three decisions, when combined together, create enormous exposure for those collecting biometric information. And so you need to understand those and be aware of this law if you're doing business in Illinois and collecting biometric information.